Before I get started with the story, let me give a shout out to Black Indie Dev on Discord for sending me this story. And this is coming out of a place called Niagara County. I'm only going to assume it's in the New York area just because of the name. I could be wrong, and maybe the article will explain to me what this is all about. So in this picture, you see a man by the name of Christopher Belter. And this guy was on trial for the violation. I'm just going to use that word in place of the other word that begins with the letter R. Y'all know what I mean. He was on trial for the violation of 4 teenage girls, and he was given a slap on the wrist as far as a sentence goes. This man received 8 years probation for what he did. And from what I gather about him, just one thing stuck out to me is that this guy comes from a very affluent background. I said this screams Ethan Couch all over again, as well as that other one that violated that girl who was drunk behind the dumpster a few years ago. Y'all know who I'm talking about. The one whose father said my son should not have to be punished for 20 minutes of pleasure. Listen, I will never forget that line. I was like, is he for real? But then again, palm colored. So let's go ahead and get into it. And I'm gonna read the title first. It says violated victims scream and throw up in court as judge refuses to jail man aged 20 who pled guilty to violating 4 of them during parties at his parents' mansion when they were teens. Let's get into it. Stunned victims and onlookers broke down in tears, with some even vomiting, when a 20-year-old New York State man who pled guilty to violating 4 teenage girls in his parents' home was sentenced to just 8 years probation by an elderly judge set to retire next month for his heinous crimes. Elderly judge. Doesn't that sound a lot like Bruce Schroeder out there with Rittenhouse? So you see what's going on? They are on code. This is the second story now. Remember, Kyle Rittenhouse took out 2 white men and severely injured another white man. And he's getting handled with the most extremely soft as cotton kid gloves I've ever seen. And now we're seeing with this story that doesn't have that much traction is he's being handled the same way. And I'm only going to assume that those 4 girls, or the girls who were teens at the time, were PC as well. So y'all see what's going on. This is Dub S imploding on itself, where they are not just showing that they can go after other groups of people, especially black people, because we're always going to be their number one target, but they're showing you that they'll go after their own, that they'll protect their own and shun their own at the same time. I'm telling you, their code system is downright despicable. The case is even more shocking because convicted Christopher Belter's parents are facing charges they groomed their son's victims by supplying them with alcohol and marijuana. So his parents are involved. Wow. I can't say I'm completely surprised though. Niagara County Court Judge Matthew J. Murphy III, age 69, told Belter on Tuesday that prison time would be inappropriate and instead ordered him to register as a sex offender. Keep in mind, this guy violated 4 teenage girls, all minors, at his parents' mansion. They said mansion, so like I told you, it goes back to him being affluent. There it is. As long as you a PC, have money, long money especially, that's a bonus, you're going to be good. Well, not necessarily, because Rittenhouse, he and his family are far from rich. So, I mean, in some cases, you'll have some that'll slip through, like him. But a lot of the times, like this case here, and Ethan Couch, because all he got was probation. And he was driving intoxicated, stole his parents' truck, and drove wildly and killed 4 people. Ironically, the number 4. And we have this one right here again, number 4. The only difference between him and Ethan Couch is that nobody died. But still, lives were affected by this. And lives were changed, but the life that should have been dealt with accordingly is not being dealt with at all. Belter had pled guilty to felony charges including third-degree violation and attempted first-degree sexual abuse and 2 misdemeanor charges of second-degree sexual abuse. But the Niagara County judge decided against a prison sentence. Belter could have been facing up to 8 years in prison for his crimes. Prosecutors do not have the ability to appeal Murphy's decision. Belter assaulted his 4 victims between February 2017 and August 2018. Well, for basically over a year, with 3 aged 16 and 1 aged 15 at the time of the assault at his family's party house in a wealthy Lewiston neighborhood just a few miles from Niagara Falls. State police claim that Belter's mother and real estate lawyer Tricia Vacancy, age 50, his stepfather Gary Sulo, age 56, and a family friend Jessica Long, age 42, allegedly groomed the 4 victims by supplying alcohol and marijuana. So they had a whole system going on here. And nothing is happening to either of them. That's what that long money, or just having a lot of money, but especially if it's long money, and being PC will do for you in America. And I wouldn't be surprised if they paid that judge under the table. And they said that judge is old and he about to retire, so he don't give a damn about this. One of Belter's victims was heard crying as the judge read out his verdict Tuesday, while Stephen Cohen, representing one of the victims, told DailyMail.com that his client threw up after the decision. If Chris Belter was not a white defendant from a rich and influential family, it is my belief he would surely have been sentenced to prison. And that is our belief too. I wholeheartedly believe that. Judge Murphy told Belter that his 8-year probation would be like a sword hanging over your head for the next 8 years. Okay. They could have did that with him being in jail. I agonize. I'm not ashamed to say that I actually prayed over what is the appropriate sentence in this case because there was great pain. Please. There was great harm. There were multiple crimes committed in the case, Murphy told the shocked courtroom. It seems to me that a sentence that involves incarceration or partial incarceration isn't appropriate, so I'm going to sentence you to probation. The judge, who will retire next month, did not offer any further explanation for his decision not impose jail time on Belter. Only overseeing criminal cases in Niagara County since 2017, Murphy has not ruled on cases of this magnitude in the past. He currently works as a judge for the county and surrogate courts in Niagara County, New York, having been elected to the role in 2007. In addition, Murphy serves as a part-time state Supreme Court justice handling part of the county's civil litigation calendar. He also handles cases involving wills and estates, as well as Niagara County's pistol permit hearings. He was later reelected in 2017 as a judge for the Niagara County court system after running for the position unopposed. Due to his age, Murphy will only be able to serve a few more weeks as an elected judge before he reaches New York State's mandatory judicial retirement age of 70 next month in December. Cohen, litigation chair at Amherst-based legal firm Hogan Willig Pia LLC, revealed to DailyMail.com Thursday that his client threw up after the contentious decision. The greater harm, however, the attorney then added, is that the sentencing in this matter would seem to perpetuate the insane belief that violation is not a serious crime and that its occurrence results in little consequence to the perpetrator. Our society needs to do much better. Belter's mother, stepfather, and a family friend have all pled not guilty to charges of child endangerment and unlawfully dealing with a child. The 3 adults are still due to go on trial, and I'm sure they're going to be hit with a slap on the wrist, because if they are just aiding in this and what they did and they plead not guilty, whatever the case may be, they're probably going to convince them to plead guilty and take the plea deal, and they're going to walk just like this guy. Vacancy, his mother, allegedly smoked marijuana with the teenage victims and supplied them with Jello shots. She, along with Sulo, faced 30 criminal counts in connection to the alcohol and drug-fueled parties at their home. Long faces single counts on her charges. At the time of the plea, Belter was placed on 2 years interim probation by Judge Sarah Sheldon, who has since retired, which allowed him the opportunity to apply for youth offender status. This would have lessened any potential prison sentence he could have received and prevented him from having to register on the sex offenders list. However, Belter revealed in court last month that he broke the terms of this interim probation by installing software on his computer to watch pornography. Wow. Had he not done that, he would not have to register as a sex offender. But he violated his interim probation by doing that. So this just shows you right here that even on an interim level with probation, he's not taking this seriously. But they still gave him probation for 8 years anyway. What makes him think he's not going to violate between now and by the time he turns 28? Because that's when it'll be up. After all, Ethan Couch, he was put on probation as a young teen, and he broke that probation not soon much, like a couple years later. And then hopped the border to Texas with his ratchet mama in tow. And now they finally decided to give him some kind of prison time. Not for what he actually did that should have landed him in prison, but for the act of breaking probation for what he did. Per the Buffalo News, Belter then told his probation officer that he had been watching pornography since he was 7 years old. During the case, the fourth victim gave a statement describing the assault on her, commenting on which Judge Murphy said he told her to stop being such a baby. The defendant told her that if she stopped resisting, it wouldn't hurt as much. Prior to sentencing, WKBW reports that Belter addressed the courtroom to reveal his deep shame and regret for his actions. He said, "I hope each of you could close that wound I gashed. I know, though, that a scar will remain that will serve as a reminder of the evil that night." But it said that this spanned over the course from 2017 to 2018 in over a year, unless clearly they probably wasn't all there at the same time. So that this was a span over different times. It's almost like it was a cult, because you got to think, he did the violation and his mother, his stepfather, and the family friend did the supplying of the marijuana and the alcohol. So it almost was like a coerced thing, like a cult thing. Imagine had he had not gotten caught. How many other victims would have been there and had to face and deal with what he did and was doing. Belter will appear in court again on December 3rd so that a ruling can be made on what level of sex offender he will be classified as. Shoot, with him not facing any jail time, I don't expect the sex offender level to be that high. He might have the first level or whatever the lowest tier level can be. Only overseeing criminal cases in Niagara County since 2016. Judge Matthew J. Murphy III has not ruled on cases of this magnitude in the past. So I had to pause it right quick because for some reason the article, whoever wrote it, they put something in here twice at the same. They put something in here twice. So let me just go ahead and skip around just a little bit. It says he presides one afternoon per week over integrated domestic violence court and spends part of another day in surrogates court handling cases involving wills and estates. He also handles the county's pistol. Okay, I read that part already. Let me continue going forward. He previously worked as the Niagara County District Attorney for 16 years and has also taught criminal and civil trial techniques at the Attorney General's Advocacy Institute in Washington, D.C. It was during this period as district attorney that Murphy also created a domestic violence program, which proved so successful that it became the model for the rest of New York. The program was introduced in 1994 by Murphy after he grew concerned at the number of family murders taking place in Niagara County. He gathered all of the stakeholders as well as researchers at professors from the law school at State University of New York at Buffalo, and together they put together a set of protocols for handling domestic violence cases. These included the police, prosecutors, the courts, and social service agencies. In 2014, Murphy made the controversial decision to dismiss a marijuana possession indictment against two defendants. Shatik Payne, Michael Payne, and Joaquin Sylvester were stopped by police officers while driving around in a $40,000 vehicle. A search was then conducted, during which 7 pounds of marijuana, 27 oxymorphone pills, and a stack of counterfeit money were found. Michael Payne died before he could appear at trial. Murphy decided to throw the case out against the two remaining defendants, describing the stop made by officers as racial profiling and was a case of driving while black. Now notice that they had to throw that in there somehow to say, well, he's not doing this because he's white. And I'm talking about with this case. He's not doing this because he's white. He's doing it because he's trying to be fair. If you don't get out of here with that, what happened with that case is way less compared to what's going on here. He rejected the evidence presented by officers on the grounds that he found the stopping of the vehicle to be improper. Next month, Murphy will turn 70 and he will be able to retire. It's so many red flags with this story, like between this guy, his parents, the family friend, and the judge. It's like they are all in cahoots with each other. And this is where this is how privilege grandstands. This is privilege this is white privilege grandstanding at its finest and its highest. When you are PC and you have money and you have power and influence, you can practically get away with anything. And I do mean anything, even if you get a slight bit of what will be a tinge of a punishment. And all he got was 8 years probation. Mind you, like I said in the article before, he violated the interim one when he decided to download pornography, which was a violation of the probation, was to not have that kind of stuff in your possession. And he had to confess to that because I'm sure they asked him, did you make any violations on your probation? And it's not like they wasn't going to find out if he had sat up there and lied. But wow. Yep, looks like another one has gotten away. I can't say that I'm too surprised or shocked by anything that I just read. They can try to rework this and rewrite this and say that this isn't what it is, but it is exactly what it is. And it is what it always has been, and unfortunately, until something changes, will continue to be. So I'm gonna go ahead and end the video on that note. I already know y'all about to sound off in the comments, and I cannot wait to see what y'all have to say.